Plea bargaining. Definitely the most fluid stage of a federal criminal defense process, because as you can see, plea bargaining is happening throughout. It can happen from the first call with the prosecutor up to the day before, well, not the day before trial. Judges usually set, in most districts, in my district and other districts I'm in, they set a time for when you can enter, the last date you can enter into a plea, which is also not like state court. But it's a very fluid process. Very different than at the state level. Plea document in federal court is a very long document. In state court, plea hearing usually takes about maybe tops 15 minutes if you have a slow judge, sometimes 1 minute. Federal plea colloquy is a very, very lengthy process. The plea agreement itself is very lengthy and requires a lot of terms. You need to be familiar with it. And I would say that by far the most fundamental difference and the most fundamental thing to know about a federal plea is in state court, a negotiated resolution with a prosecutor is always going to be to a certain amount of sentence, okay? Every single case in federal court, whether you have a plea bargain or not, unless the client's found not guilty or the case is dismissed through a motion or otherwise, goes to a sentencing hearing. Anything in the plea agreement that you have is only recommendations. Only recommendations. The judge can reject all of them. No matter what you put in the plea, every case is going to a sentencing hearing. And it's a very serious hearing. It's a trial on what the person's sentence, their punishment should be, and that is strictly up to the judge. Prosecutor could say, Judge, this is the perfect recommendation. The defense agrees. Judge could rip it up and say, well, here's what I'm going to do, and we're going to talk about why. So the document itself is certainly negotiated. A lot of it is boilerplate. But first, most important thing, what can you really negotiate if the judge is determining sentence anyways? Negotiate what charge is being pled to. And we've talked about that. That can start from the very beginning. So instead of 25 counts of wire fraud, we'll plead to 1 count of wire fraud. We'll talk about sentencing, but that of course lowers somebody's exposure. Any plea in a federal court is going to have a factual basis. The federal plea agreement, it does have a substantial impact on sentencing, lays out the unlawful conduct that was committed. Sometimes it's in the plea in certain districts, sometimes it's a second document, and it will likely include basically making out all the elements of a crime and what the prosecutor would have proven beyond a reasonable doubt each element had the case gone to trial. And the factual basis can be negotiated between the defense and the state. Contains stipulations about the loss amount, which is huge in white-collar cases because money controls everything in white-collar cases when it comes to sentencing exposure. Critical factor, we'll talk about the guidelines. If you can't agree to a specific amount or specific recommendations, you can stipulate to a range of potential loss or potential enhancements, and that will still ultimately be up to the judge, but it will help give your client some expectation of what they're going into. Plea bargaining, plea agreements involve a waiver of appeal, okay, and they're limited waivers of appeal. There's certain ways that you can never waive an appeal, one of them being ineffective assistance of counsel, also some things related to sentencing that we'll talk about. But the plea, there's a lot of anxiety in federal plea bargaining and sentencing for the client because they're pleading to something and you can do your best determination of what their sentencing guideline range is going to look like, but ultimately it's going to be up to the judge. So the plea agreement can say which recommendations the parties can put in the plea agreement were recommending that certain sentencing factors apply and certain don't. And guideline factors we'll talk about, but it's only one portion. There's things that you can stipulate to. There are ways to limit down, even though you can't agree to a sentence, you can limit to an expected guideline range. And if you know your judge, which you must know your judge that you're going in front of, especially for sentencing, you need to know, you need to know, is this a judge that regularly sticks to the guidelines? Or is this a judge that is common to vary lower, to vary above? These things are very important. It's a good idea to try and have the sentencing enhancements locked in the plea agreement itself. So there is less unknown, and that can be negotiated as part of the plea bargaining. Again, the judge is not bound by these, but most judges, at least in the Southern District of Florida, I've rarely, if ever, will have a judge not follow the recommendations as far as sentencing enhancements and sentencing aggravators under the sentencing guidelines, which you have to be an expert in as well.